Is indeed Desert Radio. It is the bold voice. It's 95.3 FM. That is our frequency in the north. You can catch us at 105.6 FM. We're also live this particular afternoon on our Facebook platform at The Namibian, and this is The Conversation. Now, Namibia's current divorce laws as it stands is outdated and expensive, rather. This has been the feeling for most Namibians for many years. However, there are now proposed amendments to the divorce bill that would see couples only having to cite irreconcilable differences as a reason for divorce. Additionally, there are also moves to decentralize divorce courts from Oshakati and Windhoek, and sectors of society have made their contributions and feelings known towards this. However, there are also those sectors that feel this will only increase the divorce rate. To help unpack this for us this afternoon, we are joined by the Executive Director in the Ministry of Justice, that's Gladys Pickering. We're joined also by Felicity Koases, who is a drafter of laws in the Ministry of Justice, as well as Reverend Dolly Negushe, who is the Executive Chairperson of the Alliance of Christian Churches in Namibia, to unpack the issue of the amendments to the divorce law, but also divorce generally as a topic in Namibia. To all my guests this afternoon, thank you so much. And
Good afternoon.
indeed, I want to start off with the executive director. That is, of course, UED, Gladys Pickering. Perhaps just to give the listeners a bit of context as to what actually necessitated these amendments.
Thank you. The amendments were necessitated by the findings. First of all, let me highlight to our listeners that there was a project undertaken by the Law Reform and Development Commission in 2004, and a project report was in fact published on this topic. They can find this project report on NAMAPLE, that is www.namaple.org, and this report sets out exactly the what the findings were and the recommendations by the Law Reform and Development Commission on the issue of divorce. Now, this report, amongst others, proposed the following: that the fault-based grounds for divorce be taken out and a new system to be introduced only based on irretrievable breakdown, and also to simplify the divorce procedure, especially where the parties have no real dispute about the divorce and or the terms of the divorce. It has also recommended at the time that the courts be given sufficient discretionary powers to distribute marital property, and also then to the underlying basis for the amendments is to grant greater access to justice for parties who wish to terminate a marriage and to make it less costly. So three things: to take away the fault-based approach, to make justice more accessible, and to make it less costly for parties who do not wish to be in a matrimonial union anymore.
Indeed. And Reverend, this is where I'll bring you in. For years, really, Namibians have been calling for an easier process to divorce, a less bureaucratic process, which is now what is happening. So you have that sector society that's really happy with the Ministry of Justice and I guess government as a whole. But again, as I mentioned, there are some sectors of society, including yourselves, that aren't too happy with not only these amendments, but generally at the fact that divorce is being made easier. Your reaction when you heard that there are now amendments going to be made, especially to make divorce easier for those that don't want to be in a marriage?
Well, thank you so much. Greetings to the Namibian people. Thank you for having me on this platform. I think, over the past few years, the divorce rate in Namibia was a great concern because the escalation of divorce was really so high. I've just followed the different statistics, but I might not make mention of it because the experts are on board. They might give us more insight to that. But all what I can say is that, we have really a giant in the house right now that we are facing. We have the issue of fatherlessness that we as a nation has to look at, which has really gone through different platforms of engagement, whereby we as the nations come to a place of what are we going to do. And I believe that, the lessening or the making easy of divorce, with regard to that bill, it's not going to ease the problem. I believe, in my opinion, it's just going to escalate the problem, even so of the fatherlessness that we are facing in Namibia. Because I believe that all divorce actually leads to fatherlessness. Because at the end of the day, the measures that have been placed, that put in place of irretrievable breakdowns, finding of no faults, to base your arguments in divorce. I believe that it really undermines our Constitution, Article 14, which states that the family is the fundamental group unit of society and is entitled to protection by the society and the states. Consequence to that, I believe that Chapter 3 of our Constitution also is violated in this instance with regard to this bill, because the fundamental rights and freedoms enshrined in our Constitution is not being upheld at this moment by the agencies of the government. So this article is very clear, and I just have to mention that the family, is the bedrock of a society, and it is founded upon marriage between a man and a woman. It is the natural fundamental group unit of society, and it is entitled to protection. We need to protect the unit of marriage, and it has to be protected by the society and by the state as well. And it is the responsibility of the state to protect, to safeguard, and to defend the marriage institutions and the family, which is necessary for procreation and also for future survival, existence, and continuation of the nation. So when these laws are being made, or this bill are being passed through, and are not really aiming to strengthen and to protect the unit of society, I believe it is just in direct violation of the Constitution. And I also have to mention that, the main document of Vision 2030 affirms the need to uphold Article 40 of the Namibian Constitution. And I just have to quote, "The family is upheld as sacred and the most fundamental institution in the society. Therefore,"
All right,
I believe, let me just finish it. Therefore, the state should not make it easier. It's just where I want to come. It must not make it easier for people to divorce. It has to really have a form of strengthening the marriage unit. Thank you so much.
Indeed. And Edie, I want you to take, big note of what the Reverend had to say there. I'll come back to you shortly. But Felicity, this is where I'll bring you in. You, of course, were tasked with the drafting these particular laws and, of course, the amendments. I think, number one, perhaps just to add context or give context to the listeners and viewers, perhaps just to explain that process for us, really, that process of drafting these particular amendments, but also generally, there must be pressure on you, surely, because the wording is quite difficult when it comes to, this particular process. And having to look at, the Constitution and various other laws that are there. Like the Reverend said, she feels that some of these, especially, the clause and the concept of irretrievable breakdown, is in violation of, she said, Article 14, Chapter 3. Take us through all of it.
Okay. Thank you. Greetings to the listeners. Thank you for having me. Okay, so basically, let me just touch on how does a bill become a law, how a law is made in Namibia. Okay, so the first part of initiation can start by the sponsoring ministry realizing that there's a specific policy problem that needs to be addressed. Or it can also be a result of demonstrations by different pressure groups or civil society. So this specific divorce policy falls within the realm of the Minister of Justice. So the then Minister of Justice, already in 2004, I think, initiated reforms relating to divorce law because of the escalating divorces. Yes, so basically after the initiation, a specific bill has to be approved by Cabinet. So the bill went to Cabinet for approval in principle. So Cabinet said yes. Then after that, there is a body called Cabinet Committee on Legislation, which looks at it section by sections, look at policy and legal issues, and then they iron out whatever needs to be ironed out and then send it back to the, or if there are changes to be made, we'll ask the minister to make changes. After this, it comes to the drafters. It comes to the department I'm heading, and then that's where we do the drafting. Now, the role that I have is, of course, to look at the legal and if the policy that I'm translating is in line with the law also, apart from other things, which I did. In this case, one thing that we must notice is that, or that we must bear in mind is that the concept of values. The values, norms, and aspirations of the Namibian people should permeate the lawmaking process and interpretation. So I do agree with the Reverend and with the citing of Article 14 and Chapter 3. Yes, we must have regard to the Chapter 3 rights and freedoms when we are making law. I totally agree with that. But we must also know that when it comes to Chapter 3 rights, you need to balance the different rights. As much as you have the right to family, you have a right to dignity, you have a right to free speech, for example, you have a right to culture, and you have a right to life, right? So if one argues, yes, one can argue that, and it's true that family is the sacred union. Yes, at the same time, you have an individual who's living in a domestic violent environment. The individual has taken out a number of protection orders, but nothing is happening. And one day the individual loses their life because of that. So when we do policy considerations, we have to see, we cannot say one right takes precedence over the other. You have to say, okay, what about the right to life and the dignity of these other individual versus the right to family? Which one is supposed to weigh more equally? Which one is supposed to take precedence? This is where balance and policy considerations come in. So yes, apart from that, so those are some of the issues that I had to look at when drafting the bill. And apart from that, after the drafting of the bill, it basically goes to the Attorney General for certification. This is also where they look at the legality and constitutionality. So it does not end here. This is just a proposed law. The persons that will eventually make the law will be Parliament, because after the Attorney General, it will go to the National Assembly. National Assembly, it will go through 3 readings, it will be debated, and all these issues will come up again. They will decide whether whatever is proposed is in line with the values of the Namibian people or is in line with balancing the various interests. And then they will decide whether they're going to pass it or not. And eventually the president also has the final say in terms of if he considers the bill to be unconstitutional, he can take it to court, or if it does not have the required majorities in both National Assembly and National Council, he can decide not to sign it.
But in its current format, there is nothing that goes against and or above Article 14 in Chapter 3 rights.
I don't think you can take it from that point. What you have to answer is, let's say, is the bill constitutional as it is? Okay, which aspect of the bill are we talking to? Let's talk about the fault element. The Reverend mentioned that, or there was a mention of the word makes the divorces easier. I don't think that is the term that we should use. I think we should look at what is the problem with the current divorce law. What is it that we're trying to attain? Currently there are only 4 grounds of divorce, right? Either you have to commit adultery, there must be a desertion. Desertion means you leave the common home, or you make it difficult for a person so that the person leaves the common home. The other one is if the person suffers from an incurable mental illness for 7 years. The other one is if the person has been declared to be a habitual criminal by the court. So these are the only 4 grounds. So when you come to court, you are required to prove these points. You have to say X and Y had sexual intercourse on which and which date a child was born. All these things must be on your particulars, right? Apart from that, you have to go and stand in an open court where everybody is welcome. You have to go and stand at the dock where accused usually stands, and then the judge will ask you or question you regarding the grounds that you have mentioned, for example. So everybody sees you, and it's a very scary process. You understand? So you have to go through that process before the court can even consider or say, your action falls within the grounds, the four grounds. So, yes.
I'll give you a chance to continue. So I just want to bring the ED in here. ED, just in terms of, what the Reverend had to say, and this is what Felicity just echoed now. The Reverend essentially saying that this is going to make divorce easier, which isn't what we want for our society. I want to speak on the issue of consultation. Surely there must have been consultations done as these proposals were coming up. Were the churches part of these consultations?
In 2004, as I've alluded to earlier, there was a Law Reform and Development Commission project. And during the formulation or the drafting of that project report, there were some consultations conducted. I don't have a list of all the institutions that were consulted at the time, but it was quite a wide consultation. They had various public and stakeholder consultations, and that was after those consultations that the LRDC has prepared the report and the draft bill and submitted it to the then Minister of Justice. There were also another round of consultations held in 2018, and the report from those consultations were also submitted to the Minister of Justice at the time. Now, in 2018, when the consultations were held, what emerged from those consultations was very clearly, what emerged very strongly was the issue of domestic violence and how spouses are forced through the current divorce legal framework to remain in a marriage where they suffer severe abuse, also where children are exposed to the abuse, which is obviously not in the best interest of the child, and where parties find it too difficult and cumbersome and costly to approach the courts to have the marriage annulled. And that is what was also one of the reasons that prompted the ministry to move forward on this divorce bill initiative. So consultations were held, it is true. I also want to indicate that, of course, all stakeholders, the churches, any other civil society organizations, all members of the public, they are, of course, welcome to give their input at all times when the lawmaking process is ongoing. So what I also want to highlight in terms of what the pastor indicated was that it is also against public policy to force parties to remain married or in a union under circumstances where they are not interested in the continuation of that union anymore. Now, Felicity has correctly indicated that there are various rights that need to be considered in this approach. And that is what the Attorney General will do. When the bill is transmitted to the Attorney General for final constitutional scrutiny, that is what the Attorney General will do to see and if all rights were taken into account and if those rights were properly balanced against each other. So there is the right, it is true, and it is one that I personally, at a personal level, support, that relates to the fundamental unit of the family. But there are also other rights which individuals must enjoy. And I want to come back to the issue of domestic violence that is often perpetrated in marriages and where parties do not receive adequate support, counseling, and or other assistance also from churches and other institutions to make their marriages work against these odds and where they are left destituted.
Reverend, this is where I'll bring you in here because, people look at institutions like the church to save, societal institutions like the family, the setup of the family, and institutions like marriages, etc., etc. You have been saying divorces have been going on the rise. Yes, sure. But what has the church been doing about that generally? Because like you heard the ED say, there has been that complaint and that worrying complaint really of the cases of gender-based violence, but also generally just the bureaucracy around divorce and being forced to stay in an unhappy marriage. The church has a responsibility to keep society intact. What are we doing to save our marriages, to save the institution of marriage?
Thank you so much. I just want to also appreciate the Miss Felicity or
Yes, it's
that just
Felicity.
Felicity just explore on the different legal processes that actually leads to the bill becoming a law. I think that when it comes to the laws, the making of the laws in Namibia, and I think that she also make mention of it that yes, the churches has been consulted. I cannot recall where we have received invitation from the ministry with regard of from the Law Reform Commission informing us on this bill. I might not maybe not be in a position or was just not there because 2018 we were donning, the whole aspects of, COVID-19 and a lot of people were behind closed doors, trying to, to fight for their lives. So I really appreciate the notion of the broader, public participation and, that the public actually has to be involved in the process of lawmaking, being properly, especially the stakeholders like the church, for instance, being consulted on these issues because the laws that have been brought actually inform the life and the behavior of a community and a society. So we need to be keep abreast when these legal framework or legal reforms are in processes so that we can also give our utmost input. Yeah, coming to the question that you just posed now, yeah, the church has on the ground been very actively, conducting workshops, and trainings with regard to gender-based violence, and workshop addressing the boys' child issues, the fatherlessness in our nation, and so on. And I think that, what is really of utmost importance here, just to make mention, is that, we should not have to really look at divorce as a, alternative or the automatic, thing that has to be done. And that is why I just came with what I said, we must not make it easy. With our review and update of our laws, we should give us, we should have to have a premise that will encourage being married rather than to divorce. In that saying, making divorce to be the last resort after all possible avenues have been exhausted. And it should
And
not,
just to cut in
yeah.
there quickly, Reverend, what happens in instances like the ED mentioned, where it's a toxic gender-based violence household, where somebody can just not stay in that marriage because it's dangerous for their lives.
Yes,
Surely in
yes.
that case, some people might feel that divorce, not only is a last option, but is the only option.
Yeah, that's why I say that, the divorce must not be the last resort after we have, exhaust all possible avenues. It should not be, automatic something to be done. But we should address at the length, issues, as I said, possible issues of gender-based violence, possible issues of cheating, possible, because you cannot remedy a situation while you are just addressing the leaves and not go to the root cause of the problem. And I think that's actually the challenge that we will sit with, when we allow these freelance, divorce. I have to mention it that way, because it's just like a ticket of, I can do whatever I have to do, but I think what we have to look in terms of gender-based violence and all the issues that are really critical to the human, life, such as gender-based violence, we need to go into the root cause of it. Offer premarital counseling and marriage education programs that will help couples to develop communication and conflict resolution skills. Making counseling services more accessible and affordable to help couples navigate through the challenges and crises in marriages, and and also foster community support like mentorship for newlyweds or support groups of struggling couples, and making more and more public awareness to highlight the importance of marriage, the challenges it may entail, and the benefit. Because the whole concept of marriage, I think, in our society is taken so lightly these days, because people goes to the magistrate court without proper counseling, and then the next thing is divorce. I think we need to look at the real root cause of why is divorce prevalent in our society, and how can we mitigate, rather than to say without fault you can just divorce.
Indeed.
I don't think that we are helping anything, because we have to look at the greater impact of divorce, which is a danger to our society. Because
I want to bring Felicity on those points. Just take into consideration what the Reverend said, Felicity. Perhaps just break down for us these amendments that have been proposed, to the new to the divorce bill, rather, just for Namibians also to understand, and maybe if you can, join it with the context that the Reverend gave, just to perhaps list it down for us, especially like we spoke about the issue of irretrievable breakdown. I mentioned the decentralization of divorce courts in Oshakati and in Windhoek, and then we've also been hearing about the issue of the costs that has been looked at also. So if you can just quickly break down for us a few in what we can expect in terms of the amendments.
Okay. So why the amendments in the first place, after all? Currently, when you ask someone, where can I find a Namibian divorce law? You will have to look at 5, 6, 7, 8 pieces of legislation. Pre-independence legislation. Then you will have to look at common law, and then in order to determine what exactly is the process and when can you divorce. So it's very difficult to even find it. So accessibility is one thing. So that is one of the grounds, one of the reasons why the ministry also deemed it fit to consolidate or reform the law so that it's in one place. That's one. Now, currently, only the High Court in the Oshakati division can grant divorces. What the new law proposes is that regional court magistrate can grant divorce, meaning it can reach the wider public, right? Those in the remote areas will be able to approach the courts also. So access to courts is one. The second one is the fault-based aspect. Okay, I already mentioned the 4 grounds of divorce that you have to prove, and the court has to decide whether there was really whether you have proved any of the 4 grounds. Even the concept of spousal maintenance currently. In order to get spousal maintenance is money or financial assistance that you have to pay to the other spouse on divorce. So if a party asks for it, the court will in most instances grant it if there is fault. Meaning, if a spouse has committed adultery or malicious desertion, it has to be factored before spousal maintenance is granted. Of course, there are other factors considered, such as the need of the spouse asking for spousal maintenance and the ability of the other spouse. That is why we want to remove fault, because we are reasoning that why must fault be a requirement for spousal maintenance? Why should spousal maintenance not just be need-based? For example, because you decided to be a stay-at-home mom or a dad, right? A husband, or a spouse. And the other party went on and got education and stuff like that. You are 55 years old. Now you are divorcing. Spousal maintenance would be justifiable in such an instance. Yes. So that's also one of the reasons why we want to remove fault, because everything is based on fault. Any order that you ask in the divorce proceeding is based on fault. The other one is, currently, if you ask a divorce, there's an order that has to be granted. It's called restitution of conjugal rights. That order must first be granted, meaning you must go back, even if it's domestic violence or whatever, go back to your spouse and restore the conjugal rights. So you are forced to go back to a very violent or whatever environment. And that's why we are saying, why must this order be made in the first place? While, for example, there's domestic violence, and the person is saying there's domestic violence, but the court insistingly is still obligated to make this specific order. So that's some of the reasons why we have opted to let's look at irretrievable breakdown as a ground for divorce. What this means is it does not stop you as the party instituting divorce proceedings to say that he committed adultery. That's not what the bill is doing. You can still state that. You can state all the facts. It's up to you. But you don't have to state it. That's what we are saying. Because, like I said, you have to go and stand in the open court and disclose all the dirty laundry or all the things that happened. And what about the right to dignity of this specific person that is going through the divorce, right? So that's another one. The other one is the aspect of fees. Currently, just a basic divorce proceeding, unopposed divorce proceeding can cost you up to 20,000. And why? Because the lawyer will charge you for the phone call, for the application, for appearing in court. They charge you for everything, for drawing up an agreement. Unopposed divorce application will be 20,000, An opposed one is where the other party is contesting the divorce. That one can even go up to 150. It can go up to 50,000 because in such applications are usually because either they are children or they are property and there are disputes surrounding that, and then it prolongs the process.
Yeah, and
in
the
meantime,
yes,
in the meantime, the lawyer has to charge you for everything, right? If they have to travel to Oshakati, who has to bear the cost? You understand? So they and these fees are contained in the rules of court.
Okay.
Yes.
So on that particular point, how do the new amendments ease that particular burden? Because that is one that has been really weighing in on Namibian pockets for the longest of times.
Okay, so the first one is it's currently also possible they do it yourself divorce. You can do your own divorce proceeding as long as you know what documents to submit and things to do, and obviously you get proper legal advice. So that way you don't have to resort to a lawyer. But usually when there's property and children, sometimes it's advisable. People will go to a lawyer because, say now you make a mistake, it can be against you, right? But as long as you know what to do, you can do it yourself divorces. It allows for joint divorces. If you and I decide we don't want to stay married anymore, you and I can go to court and ask the court. Currently, that's not possible because you have to prove fault, right? So two parties cannot now prove fault against each other, right? So this one allows joint applications. We jointly apply for divorce due to irretrievable breakdown. So that cuts cost also because it's not an opposed divorce application. It's an application that can be dealt with, right? And then there are applications where there are no children or really sometimes no property also. There's no reason for such divorce applications to be prolonged, right? And then there's also the aspect of we have a Legal Aid Act in Namibia. A person who cannot afford a lawyer can approach the Legal Aid Directorate and apply for a government lawyer. They are currently helping, assigning lawyers also to people. The only challenge currently is the criteria. You need to, there's a certain threshold, 3,500 or below for you to be granted. But we are also looking at reviewing this criteria in order to assist more people in the divorce proceedings. And another way in which the bill is helping is in terms of the court rules, the court will allow certain divorce orders to be granted in the absence of the party. Because sometimes you don't have to be absent for the order to be granted. Because all you'll be doing is either the lawyer goes with you and gets paid, right, just to get the order or just to hear the order, or it can be done in your absence. So that's how the bill is contributing to reducing the fees.
And Edie, I want to bring you in here quickly and perhaps just also respond a bit to what the Reverend had to say. Look, of course, no one wishes for anyone to be in a violent situation, in a toxic situation. But surely, to uphold the essence and the fabric of society, some issues like counseling, some issues like arbitration and meditation going into divorces should be one that should be considered. Have these all been considered during this entire process, to also, like the Reverend said, decrease our divorce rates, or are we just making these as some people call it, liberal changes and making divorce as easy as possible for everyone?
I agree with the Reverend when she mentions the fact that we have to address the root causes for divorces. Definitely, we have to pay attention to those root causes, and that will, in the long run, contribute to lesser divorces coming to court, because you would have taken steps to solve the issues and or to create a more conducive environment within which this union can be celebrated. Now, if we as a community and as a government, as a collective, as a country, we fail to address those root causes, then obviously we are not going to see the results that we want to see in terms of reducing the rate of divorces. And one of those root causes is definitely alcohol abuse. It is one that I feel particularly strong about. But to come back to the issue of how can we then, uh, what is it that we want to achieve? The Ministry of Justice, at the core of its mandate, has the responsibility to enhance access to justice. Access to justice meaning that we want to see more people being able to go to court at a less or no cost, and also to make sure that people have access to remedies. So, in terms of this particular law that we endeavour to table in Parliament, we want to make sure that people will have access to a court which is closest to them, and not just the two seats of the High Court in the first place. We also want to see that people have access to a court in a less costly manner. As Felicity explained, what the costs are involved for divorces. And then we want to see that we preserve the integrity of the judicial process. So we want to make sure that that parties are not necessarily exposed to a indignified appearance or process in court, and that they will have a platform where the issues can be dealt with in a competent manner, but at a less costly rate. So we want to formalize the concept of spousal maintenance at the same time. And I want to make one point specifically clear, which is also a big contributing factor towards the decision to move forward on this bill. If parties remain in a formal union, they are legally married, but they have been separated for 10, 20 years, and they were married in community of property, and one of those spouses pass away, then that property regime becomes a real nightmare for the heirs who are left behind, because the other party will be entitled by the mere fact that they were married in community of property to each other to 50% of the estate of the deceased spouse, whilst they have not had any communication or any interaction with each other for the past 20 years. Sometimes these spouses are even in other countries, and we have to then pursue options in terms of international cooperation with those countries to resolve the administration of the deceased estate here in Namibia. Those are real issues that we deal with on a daily basis. So we want to eliminate or at least minimize those issues through this legislation.
Indeed, and then just as we start winding down our conversation, ED, I'll give you about a minute or two to just answer this question for us. Like you said, like both you and Felicity said, it's been since 2004 really that this process has started. People have been calling for this for the longest time. It seems closer and closer. It does seem like a reality. What are we looking at in terms of a timeline? When can we have this, actually implemented and enacted into the divorce bill? Felicity did tell us about the processes that have to take place, but what are we looking at in terms of a timeline?
Okay, so we were informed that the last date for tabling of any legislation in the current sitting of the Parliament session of the Parliament is the 31st of October. We are now on the 5th of October, and that is the date that we are aiming for.
That is the 31st of October.
Yes.
Okay. And Felicity, just from your side, in terms of closing remarks, just speak to us, again on the importance of these particular amendments generally as a whole, just to encompass package that for us rather. But also, I want to go back to the issue of the pricing. You did give us the steps on how surely it should be a bit cheaper, right, for people to get divorced, to get to this justice. But if we're looking at averages, like you said, if it's a divorce that's opposed or unopposed, you're looking at 25,000 currently. If it's a divorce that is opposed, you are looking anywhere from 50 to 100,000. What numbers are we looking at potentially with these new amendments?
Okay, I did not do an estimate, but like I said, let us take, for example, a joint application.
Okay.
A joint application is definitely going to reduce costs. A joint application where the party says our divorce is irretrievably broken down. It's definitely going to reduce the process. It can even reduce it up to a 10,000. Another amendment that I forgot to mention is we're going to amend. There's also amendment to the magistrates, since the regional magistrates are going to grant divorces. The judge president will be able to make rules that deal with limiting the cost regarding divorces and in regional courts. So that's another aspect. Of course, when there's no real disputes, for example, cost will be limited. If a party doesn't have to appear or lawyer doesn't have to be appear and divorce can be granted in the absence, that means the lawyer will not charge you for appearing. Maybe it's a 4,000. So there will definitely be a reduction. But I also have to say that sometimes society, they would trust the lawyer to do it, and they would still go to the lawyer to do it instead of doing it themselves. I know there are a number of people who have done divorces themselves. So that's also, if you do your own divorce and you know the legal proceedings, you've definitely cut any cost, and that's it. Only other aspect of, I want to talk to what the Reverend said. Yes, the bill is not going to take away the root causes of divorce, and that's a very important thing the Reverend mentioned. And maybe, I don't really want to sound funny or anything, maybe we can look at criminalizing adultery.
Well,
yeah, no, I'm just saying, because there are various things that one can do. Like the Reverend said, they are doing education and stuff like that. But remember, sometimes you just reach a certain portion of society and you don't reach everyone. So what can we do? What can we do is it should be a joint effort. Government and law cannot solve everything.
100%. And we just quickly want to bring the Reverend. We lost her on the line. Reverend, we lost you on the line there. We just quickly want to bring in. I'll literally give you 30 seconds to just give us concluding remarks. One thing that Felicity said, maybe it's an option, maybe it's not an option, is looking at things like criminalizing adultery and criminalizing all the other things that might be leading to divorce. Just give us your concluding remarks. 30 to 45 seconds, please, Reverend. We don't have much time. Reverend, can you hear me?
Yes, I can hear you, sir.
Just your concluding remarks. I'll give you 30 to 45 seconds, just to sum your thoughts up for us. I'll give you an interesting point quickly. One suggestion that came up was maybe looking at criminalizing things like adultery, criminalizing things that might be contributing to divorce. Your 2 cents on that. Again, 40 seconds for you, Reverend.
Okay, thank you so much. So sorry, I've just lost some time because my phone is keeping on, going off. But my last remarks would be, I believe that the divorce without assigning fault, has several consequences for, to the well-being of our society. Number one, I think I just want to say that it removes the accountability concerns. People being, accountable towards one another, also accountable, and responsible within the marriage. And also, I believe that it also is just going to weaken the whole unit of marriage, because if people just decide, we're just going to divorce without no fault, it appears it is encouraging more casual attitudes towards the marital commitment. And I think it has also, economic implications, because somebody says that it's less cost effective, but I don't think so, because the cost that one can bear, with it's a marriage that is no fault finding, the aftermath of that marriage.
Indeed.
In terms of the financial matters can become.
Reverend, unfortunately, we do have to cut and conclude our conversation here. Reverend, I'm so sorry we've run out of time. That's okay. That's completely fine. But we do thank you so much for making some time for us. Same with you, Edie and Felicity. It's a conversation that I think will still be ongoing. We're looking at that October 31st date, Edie, and we're looking at it closely. And for the rest of Namibia, they will definitely be commenting more on this issue. But for your time this afternoon, we thank you all so much.
Thank you. Thank you very much.
And just like that, we do conclude and shut down the conversation this particular afternoon. It's been a pleasure being in your company this afternoon. Thank you so much for making some time for us. Do continue this conversation by adding into our comment section, to our comment box. It will be an interesting story to read. I'm sure the journalists at the Namibian newspaper were looking to pin something from this. The issue of divorce, are they making it easier? Should it be made easier? Well, you have the answers to that.
By definition, the word globetrotting means the action of traveling widely around the world.
He's not traveling wide, that's your opinion.